Welcome, everyone. We are letting folks in from the waiting room. It's going to be just a couple of moments here while I let folks in. So go ahead and just hold up for just a moment. I'm waiting for Michelle Dellino from Dellino Family Law Group, who will be joining us here in just a couple of minutes. So please bear with me. I think we're going to be running just about 2 or 3 minutes late. So hang out for just a minute, and Michelle will be joining us here very shortly. Thanks so much. Well, there she is. That didn't take very long at all. Okay, everybody, welcome to the webinar. Today, this webinar is about domestic violence, child custody, and family law. And thank you all for joining us. Just going to take a quick moment to introduce myself. My name is Melissa Rosenberg, and I am a licensed independent clinical social worker here in Seattle. I'm a therapist in private practice with a specialty area supporting clients who are going through the divorce and separation process at any stage, contemplation, mid-process or after the fact. I work with both individuals and couples in a therapy setting. But today I'm here as a moderator for this webinar. And so in just a moment, I'm going to have Michelle introduce herself and launch into our topic. But I want to also just give you a quick rundown about the logistics here. Michelle's going to be talking a lot about this topic and diving in and presenting a lot of information, but you may have questions that come up along the way. So there's a couple of ways that you can ask those within the format of this webinar. The first thing you can do is send it to me in the chat. If you put a question in the chat, no one will see it but me. I will pose it, and we'll try to get it answered. Another way you can do it is the Q&A option in Zoom. And related to the Q&A, if you put your name in there, you can either mark yourself as an anonymous attendee or you can not. And if you don't, then your name will pop up and the group will see who's asking the question. But if you want to be marked anonymous, you can do that. Okay, so I'm looking forward to having you guys, ask questions and get a lot of information, and we'll go from there. So I'm going to turn it over now to Michelle Dellino with Dellino Family Law Group.
Hi, I'm Michelle. Thanks for being here today. I am the owner and attorney at Dellino Family Law Group. We have offices in Seattle and Bellevue. We help clients literally all over Washington State, although the majority of our work is in King, Pierce, Snohomish, and Kitsap counties. So if you're here today, you probably have questions about domestic violence, family law, maybe divorce, parenting plans. You could be looking for a lot of different information. So I'm going to talk through some information that is probably relevant to you. Some of it maybe is, some of it maybe isn't, depending on why you're here. But that's why what Melissa mentioned is a great opportunity for you to ask specific questions. You need to know that I'm an attorney, but I'm not your attorney unless you have an actual attorney-client relationship with me or you have an attorney-client relationship with another attorney at my firm. Nothing that I say here today is legal advice. This is legal, it's information, really. It's generally information. So if you ask a question and I answer it, that should be for informational purposes only. If you have specific questions about your case, you should talk to an attorney, no matter who that may be. So with that being said, I'm here happy to try to answer some of your questions, and I will do that. So first of all, we're here to talk about domestic violence as it relates to divorce, parenting plans, any number of situations. And domestic violence is really an evolving topic in Washington State. Washington State legislature acted to expand the definition of domestic violence last year. And we're going to talk a little bit about that. We're also going to talk about protection orders, restraining orders, no contact orders, what the differences are between those orders, because it's important that you know. And we're going to talk about what domestic violence is and what it isn't. So, and then how that can affect your case. So that's a little bit about what we're going to delve into today. So Washington recognizes the detrimental effects of domestic violence on families, and there are specific provisions to address these issues in the context of divorce, in the context of what I would call a standalone protection order that doesn't have anything to do with the divorce, and also in the context of a parenting plan. So domestic violence affects a lot of people, and so you can't pretend that it exists in this little silo over here that has nothing to do with your divorce. Like, that's just not realistic in most people's instances. You might hear the term 191 restrictions. You may have heard that, you may have not, but if you're involved in a parenting plan issue with DV, you probably heard it. So what are 191 restrictions? We're going to get to that. But RCW is the Revised Code of Washington, and the Revised Code of Washington really emphasizes the importance of ensuring the safety and well-being of people who are victims of domestic violence, specifically also children and parents who are victims of domestic violence as well. There are additional protections in what we call the RCWs. So 191 restrictions. 191 restrictions are in reference to RCW 2609191. It states that a parent's residential time will be limited if it's found that that parent has engaged in acts of domestic violence, as defined further in another RCW. So when you hear about restrictions, what does that mean? It means there's something, usually a finding of domestic violence or other action that's happened that's a basis for restrictions. So obviously, if there is a domestic violence protection order, if there are other allegations of DV that are found to be credible, then those things can act as restrictions, and the 191 refers to that statute that says so. So that's something I just want to get out there right away. There is a basis for restrictions in parenting plans if there has been a finding of DV, or even if there's not a protection order, there can still be a basis for restrictions in parenting plans. But before we really get down that road, because some people here probably don't have kids or parenting issues, some of you maybe do, but it's very important to talk about, like, what is domestic violence? Because a lot of people don't know what it is, and what it is and what it isn't is also very clearly defined in Washington law. And it can be confusing, but it's important to talk about. So the statutory definition of domestic violence in Washington is this. I'm going to go over it. I talk really fast, so if you haven't heard me talk before, you might not know that. So I'm going to slow it down a little bit to talk about what domestic violence is. But if you miss any of this, this video will be available online off our website on our YouTube channel, and you can ask Melissa, but I will try and slow it down. So RCW 7.105.1.01 subsection 9 defines domestic violence as physical harm, bodily injury, assault, or, this is a really key one, the infliction of fear of physical harm, bodily injury, or assault. And I want to break it down and just talk about that. There's more to the definition, but let's talk about that. So basically, domestic violence is, bam, you could be assaulted, physically injured, or somebody could never lay a hand on you, and you could have the infliction of fear that that was going to happen. And so that is still domestic violence. So if I am sitting here and my husband is sitting there and I act like I'm going to throw this baseball at his head, which would really hurt, and it's reasonable, and we're fighting and it's reasonable, and I don't do it, or I miss him, then he had a reasonable infliction of reasonable fear that I was going to seriously injure him. That's domestic violence. You can't threaten someone, even if it's not a physical threat like that. You can't tell them you're going to kill them or whatever. And if it's a reasonable fear, that is still domestic violence. So it is the actual infliction of physical harm or the reasonable fear of an infliction of that physical harm. So that's one part. The next part is bodily injury, which also relates to that. Non-consensual sexual conduct or non-consensual sexual penetration. That's another subsection part of domestic violence. Now, in Washington, you can get a sexual assault protection order as well, but you really don't need to, because a domestic violence protection order covers family, household members, dating partners, covers sexual assault. And it's not just sexual penetration, sexual touching, sexual conduct. The definition in Washington has now been expanded to include non-consensual sexual conduct. You could touch someone, you could do any number of things that are conduct that also are domestic violence. Coercive control is another part of the definition, and we're going to talk about that specifically. That's also a recent addition. Coercive control is not a physical act, so that's important for you to know. Unlawful harassment or stalking. So again, domestic violence in Washington: physical harm, bodily injury, assault, or the infliction of any of those things, non-consensual sexual conduct or sexual penetration, coercive control, unlawful harassment, or stalking. All of those things. But then, to be a domestic violence protection order, it needs to be from one intimate partner to another intimate partner, or one family or household member to another family or household member. So it can be dating partners, it can be your mom, it can be, whatever, a family or household member, someone in your household or a family member. If you have that relationship piece and you have one of these things that we've just talked about, you have domestic violence. So That is what domestic violence is. The next thing I can talk about, Melissa, do you want me to answer any quick questions or do you want me to keep going?
There is a question just asking, what about any harassing behavior such as recording without consent and in the home using kind of intimidation,
Mhm.
non-sexual, but intimidation, and recording without consent? Does that fall into one of those categories?
Probably falls into coercive control. I will say something about recording. I was going to touch on this later, but thanks to that great question, I'm going to touch on it now. Washington is a two-party consent to record state. So what that means is if you want to record another party then there should be an expectation of privacy and they wouldn't have a reason to think they're being recorded. Like a Ring camera, somebody knows they're being recorded. You don't have to ask for their permission, right? If you're out in a public place and you're recorded on a security camera, nobody has to ask for that. But to actually record someone's speaking, you have to get two-party consent to record. So like, for example, I used to do criminal work. When I'd interview somebody, we'd all be sitting there and everybody has to say, I give my consent to record. You have to consent it. You can't record somebody's phone calls. You can't record a conversation with them and not tell them. It's actually illegal. It's gross misdemeanor in Washington state. There are a few exceptions to that. Like if someone is in the act of committing a crime against you, there are exceptions to the recording consent. But for the most part, you can't just record somebody without their consent. It's not okay. You can't pull out your cell phone and record somebody if they don't say it's okay. So that could be a crime in and of itself. But aside from that, intimidation, controlling behavior behind closed doors, things like that falls under likely coercive control. So we'll talk about that. And that things like this kind of behavior is a reason for the expansion of the definition of domestic violence in Washington. So that's something that I think is helpful for people to know. So before we start talking about
Sorry, one other thing. How about abusive text messages? Does that fall into that?
it, absolutely can. I not that long ago obtained a coercive control protection order where one party literally never put their hands on the other party, but there was a series of text messages and also messages in our Family Wizard, which is a parenting program, and it was all in writing. And yes, you can have messages that evidence domestic violence. So yes, that is a very real thing. And that's one thing I'll say too, just, part of the nice thing about these webinars when we can actually have you ask questions is we can answer things that you really want to know that are relevant. So now I'm thinking to tell you something I tell people to do that you should do is don't delete or destroy your messages. Download them, save them in a folder in case you need them. Whether it's text messages, it's not just that. It can be our Family Wizard, which is a parenting program. It can be emails. It can be Instagram messages, Snapchat messages, any of those. Save screenshots, download them, save them. Those can be very useful to you. And I'm about to talk about domestic violence protection orders a little bit. And one thing that's really important to know is in Washington and any state court, there are rules of evidence. And so that is what you can and you can't present to a court. Okay. And I'm not going to give you a lesson on evidence, but I will tell you the most common problem that people have in getting something into court is whether it's hearsay or not. And hearsay is basically any out of court statement brought into court and being asserted like, hey, this is true, and it wasn't talked about in court. So you have to have ways to get that kind of information in. And so you can do that in family law proceedings with writings a variety of ways. But here's the kicker. In a protection order action, the rules of evidence don't apply. And the reason that the rules of evidence don't apply is so it's easier to get more information in front of the court to really talk about, what's going on. So for example, if I was in a family law proceeding and I was trying to get a temporary parenting plan, I couldn't say in my declaration, if I'm the party, I couldn't say, my kids told me he did this or that. You couldn't say that. It wouldn't be admissible. It's an out-of-court statement by your kids that can't come in. But in a protection order, you could say, my kids told me this. The teacher told me this. You can say those things, and they can come in. And you can have writings from other people who are not testifying to them. You get a lot more leeway with the rules of evidence because the court would rather err on the side of knowing more than less, and then they can decide how much weight to give that evidence. But those are different rules than if you are just getting a restraining order in the family law process, getting a temporary family law order, or you're in trial or something along those lines. So it really, it depends. But anyway, there's a lot more leeway. So protection orders is often known as a DVPO, so that's something to know. But the idea is to be able to protect someone from abuse. And getting a protection order can be something you do in the beginning of your case, your family law case. It can be totally independent of a family law case, but you can get what we call an ex parte protection order, a temporary protection order, on an emergency basis. By the way the process starts is you fill out a petition, and then you either have your attorney go in or you do it yourself, and then you ask at that point in time for a protection order to issue. The other party is not typically aware at that point, because if they know about it, they might retaliate against you. So you're getting that emergency protection in place. Then they will get served with the protection order. And then there's typically 2 weeks of temporary protection until there's a hearing, when they have an opportunity to come and say why that should or shouldn't stay in place. And they have an opportunity to file a response, and then you have an opportunity to file a reply. But getting a protection order, like I said, can be done with a family law case or without. You don't have to have a family law case or a divorce or anything like that to get a protection order. Protection order, the court's going to be looking at, does the conduct fall in that definition of domestic violence I just talked about, and what protection is necessary. If there's children, like if you're seeking a protection order and it's for children and a parent, sometimes the court will enter a longer temporary order and ask for a domestic violence evaluation to be done. Or maybe there is a guardian ad litem in a parenting case that's doing an evaluation, and they might just extend that temporary protection before issuing a full order to allow more investigation to be done. And that's typically only if there's kids involved, because the court wants to be really sure before they do something that damages contact between a parent and a child. So that's one thing to know. I think it would be probably a good idea to talk about the different types of orders, so I can do that. But before I do, any questions, Melissa?
Yeah, a question here. This participant's just talking about how they have a temporary family law order and a protection order against her husband, and feels like the husband's kind of getting away with things even more than the kids are being protected. She didn't really specify, but I wonder if you can say anything about maybe just enforcement and what happens if you feel like it's being violated.
Yeah, and that's a good segue into talking about the different types of orders. So a protection order is the highest form of protection. What that means is if you call 911, someone's going to come. So a protection order also has what we call a companion law enforcement information sheet. So when a protection order enters, there's a information sheet that's sent to law enforcement, so law enforcement is aware and it's in the system that this happens. Okay. So if you have a situation where you have a protection order and someone's violating it, you need to either call the police, or if you have an attorney, you need to tell them, but really you need to document it, and you need to seek a violation. You need to basically seek to hold them accountable for a violation if that is something that's going on. If you have a situation and it's like questionable whether it's really a violation or not, you should ask your attorney what they think. But it should be pretty cut and dry as far as contact, who's supposed to have contact and who's not. What that contact is supposed to look like. If you have a parenting case and you're not supposed to have contact with the other parent, but for maybe you can have it about parenting only in our family wizard, or there's specific parameters. But then if the other party is getting in our family wizard and talking to you about stuff that has nothing to do with parenting, that's a violation. So there can be any number of ways things can be violated, but you should, if someone shows up at your house, they're not supposed to be there, call 911. If it's something like, oh, I think I got this message that violates the order, talk to your attorney about it. But the order is really only as good as the enforcement is, so you kind of have to enforce it. Otherwise, it's not really serving you, although it can have implications in your parenting plan, which we'll talk about. So, okay.
One question here asks, so after domestic violence has happened, when is a good time to file, and what is the time frame for it to be effective?
ASAP. There's no time provision so you can, I've had cases where someone will claim domestic violence months or years earlier. There's nothing that says you can't base a protection order on prior acts of DV. However, you really, really should act as soon as possible, because I'll always tell clients too, well, it hurts your credibility if DV happens and then you say, oh, they're a danger to the kids, but then you went out of town for the weekend and left the kids with the other party. So but this DV happened before, you weren't that worried about it then when it was convenient for you to go out of town, right? Or if you all stayed living together and everything seemed fine, and, which a lot of times DV you know, it takes people a long time to leave, and that's recognized, which is why there's no time bar on how far you can look back. But the sooner in time, the more close in time to the action that you take action, probably the easier it's going to be for you to get an order. And if you go and get that temporary order I was talking about, you get it immediately the same day if the court agrees. If the court doesn't agree that there's a basis for an order, they'll set a return hearing in a couple of weeks, and then you'll talk about it then. But most of the time, if there is a credible allegation of domestic violence, the court will issue a temporary order and you have protection then. Law enforcement will serve it on the other party. They will have them leave the home, and they can't have contact with you. So you get protection immediately. So that's important. That's like really important for you to know. So there's different types of orders. Protection orders, like I just talked about, you can get on your own or as part of a case. Sometimes people will get a restraining order in the context of a family law case as well. You can still seek, you can still claim violence happened. Sometimes though, it might not be in the statutory definition of domestic violence, or sometimes people just don't want to get a protection order. They want to get a restraint that stays in place during a case, and that's sufficient. So you can seek a restraining order, and while a restraining order still has a law enforcement information sheet, the police still know about it, it's still a court order, slightly different and not the same form of protection as a protection order. Protection orders can be renewed annually. They have a different set of standards. So that's the difference. A restraining order and a protection order. Restraining orders can also apply to financial matters. There is basically an automatic financial restraining order that goes in place with every divorce case, and that's just automatic. But you can seek a restraining order as well to restrain people from doing certain things, to having certain levels of contact. All those things can happen in the context of a restraining order. The next thing aside from a restraining order that can come into place is something you might hear called a no contact order. No contact order typically happens if there is a criminal domestic violence case, very often like a misdemeanor assault. It's not uncommon to have somebody assault somebody, the police get called, and there might be domestic violence criminal case, a protection order case, and a family law case. It's really common for all of those things to be going on at once. And if they are, a criminal court will issue a no contact order that says the alleged victim can't have contact with the accused person. So you could have a no contact order in place at the same time as then you go and get a protection order, and you've got that going too. I've had a lot of cases with that, but they're all different orders that serve different purposes. So it's important to talk about that. Navigating domestic violence in the court system can be difficult. So it's important that you have advocacy and you understand what the goals are of the protection order for you, or if you are accused of DV and you didn't commit it, how you can defend yourself against that. Because I hate to say this, it's so true. People do fabricate allegations of domestic violence. Sometimes they'll fabricate an allegation of domestic violence to try to get an advantage in a parenting plan. I would love to say that's not the case, but it definitely happens. So you need to be able to protect yourself and defend on that. I think it's also important to talk about the expansion of domestic violence in Washington. So the amended legal definition of domestic violence now includes additional clauses that we talked about earlier. Non-consensual sexual conduct or non-consensual sexual penetration, coercive control, and unlawful harassment. Those are all new. We didn't have those included in our statute before. So including the term non-consensual, that means that you also have to define what is consent. So basically, consent means words or conduct indicating that you're giving agreement. So there's several situations where consent's not given, such as when someone revokes their consent and said, you could say, I want to have sex with you. Then you could be like, you know what? We started to, no, I don't. I've revoked my consent. That is completely okay. Or if you can't consent voluntarily, if you have someone that's underage or a child, they can't consent to sexual conduct. Or if someone is intoxicated and they're not in a position when they can consent, then they can't legally give consent either. So it's also important too to know that there are situations where if somebody has control or custody over somebody, like somebody who, I don't mean parental custody, but somebody who is incarcerated or detained, they also, can't give consent. So anyway, it's important when there's minor or children involved to realize that there might be a claim about non-consensual sexual conduct, and any contact between a children and a minor, whether it's a parent or other person, is always going to be deemed non-consensual because children can't give consent. So that's important for you to know. Coercive control. Someone asked a question earlier, and I mentioned that coercive control is an expansion of our domestic violence law. So coercive control, under the latest legal definition, Coercive control refers to any pattern of behavior that's designated to inflict physical, emotional, or psychological harm to prevent the victim from living freely. So what does that mean? It means a pattern of conduct where if someone's telling you every day that you're a piece of crap and you're not good for anything and really breaking you down, and there's a pattern of conduct, and maybe it's in text messages, maybe it's in person, and there's a pattern of verbal and psychological abuse, and it's defined, and it's basically serving the purpose of not allowing you to otherwise like have free will and do what you want to do, and it's breaking you down. That is coercive control. That is domestic violence in Washington. And that's a very new thing for us over, the history of domestic violence, but it's important. Certain protective actions, in good faith, if you're acting, don't count as coercive control. So like, let's say if you're doing something to protect someone, then, and you might say or do something and it's to protect a child or yourself, there's exceptions to coercive control. Coercive control is basically efforts to intimidate, control someone, threaten someone. This can include online threatening or harassment, make someone dependent on you, confine someone, isolate someone, deprive someone of basic necessities or financially control them, make them come to you for money and not allow you to have any kind of free will without you knowing what's going on, monitoring them, controlling your movement or communication, or subjecting someone to what they call psychological aggression. So basically, it's controlling abusive behavior that takes a pattern that is intended to limit your free will. So it's important for you to know. It doesn't mean that someone has to be like documented, this has psychologically damaged me, but the impact of the behavior can be traumatic and severe, and that's good enough for it to be found as domestic violence. So these changes really affect protection orders, because before the definition of DV was a lot more limited and you could have psychological abuse and it was not okay, but it wasn't domestic violence. Now it is. So that's very important for you to know. Someone can commit domestic violence in Washington without laying a hand on you, and it doesn't make it any less serious. So you should know that. Victims can now seek a petition for domestic violence, sexual assault, anti-harassment, stalking. Those are all reasons to seek a petition for protection. So instead of trying to figure out what's the right thing for me to do here, if you think this might be happening to you, you can talk to an attorney. You can go to the courthouse, and there are domestic violence advocates there that can direct you to the right forms. Things like that are definitely possible and important. So I hope that's helpful. It's important to talk about parenting plans and the impact on what happens if a protection order enters and there's a parenting plan. So before I do that, are there any other questions?
Yes, there's quite a few. So we'll ask a few.
Go ahead.
Okay. What happens if both parties could meet the technical definition of DV, but one is more frequent or dangerous? Like, say one person screamed and thrown things in the past, but not caused physical harm, and the other physically has endangered and threatened and more. What happens if
So
both parties?
mutual DV, I mean, that happens a lot, unfortunately. And I think it's going to be, I mean, nothing happens unless someone seeks an order. That's the whole thing too. And I've had situations in family law cases where maybe both people are making allegations, and then maybe there's a guardian ad litem or a parenting evaluator, or maybe there is what's called a risk assessment being done by family court services. And in those instances, an evaluator could find that both people have restrictions for domestic violence, and that's really tough, but sometimes that happens. But it's not uncommon either for one person to seek a protection order and the other person's like, wait, this person is also an aggressor, and the court then, they have to weigh what's credible here and what's not. But if you're not seeking a protection order or you're not seeking a restriction based on DV, then nothing's going to happen. But it is possible in an evaluation for an evaluator to find that both parties have perpetrated domestic violence. That's not common, but it definitely does happen. I've seen it happen. And then the court has to make decisions about what's the appropriate kind of plan to put into place here. So.
And there's a couple of questions on the topic of coercive control, so I'll try to grab those real quick. Participants asking, at what point does a child's age come into play? There's a situation where a 12-year-old doesn't want to go to their dad's because of coercive control and fear of retaliation by the father. They have a parenting plan, since the kid was 4, but what do you do in those situations if the child is a little bit older and voicing that they don't want to go, potentially because of coercive control issues?
Well, number one, if a child has a reason that they feel unsafe about going, I'm going to tell you this too. You have a duty. There's a case in Washington called Marriage of Right Out that's very clear about resist refuse situations. Resist refuse situations are when you have a child that doesn't want to go with the other parent. And a very common question is like, when when does a child get to make the decision about when they go with the other parent? Never, 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 never. I cannot stress this to you enough. And I'm telling you this for your own protection. If you have a 13-year-old that doesn't want to go over to mom or dad's and they're saying it's because they don't like what's going on there, if it's a serious safety issue, then you should be seeking a modification or a protection order to keep your child from having to go. But if it's just the kid is saying, I don't like this, it's going on or whatever, or they just don't want to go, you have an affirmative obligation under Marriage of Right Out to use best faith efforts to do everything possible to try to facilitate the visitation. If not, the other party could seek to hold you in contempt and likely be successful. It's not enough to go to the kid. Hey, do you want to go? Kid says no. Then that's not enough. You have failed to comply with your obligations to try and facilitate visitation, and you could be held in contempt. 2 residential contempts in 3 years is a basis to modify a parenting plan. There's also a school of thought right now amongst parenting evaluators and the AFCC, which is the American Association of Family Conciliation Courts, that really believes that resist refuse situations are only resolved when one parent's part of the problem. They're only resolved by taking the children and placing them with the other parent they don't want to be with. And I'm not saying that's a good idea, but we're seeing that happening. And that is something that is happening. So if your kid doesn't want to go, it doesn't matter how old they are, you have to at least try to make it happen. You have to withhold privileges. You have to do everything possible. It's not enough to ask the child, do you want to go? No, that's not enough. But the whole thing about DV here is if there's something going on over there where there's coercive control or psychological abuse, then you need to act. And this is on my list of things to talk about. So I'll talk about it now really quickly. Modifications to parenting plans. Once you have a parenting plan and it's in place, if things are going on and they need to be changed, what you should do is you should seek a modification on the basis of detriment to your child in that other parent's home. Modifications of parenting plans can be given to accommodate safety concerns, and that can include changes to visitation schedules. But like if you don't do anything and you just don't send the kids and you're not like claiming there's a real problem here, then the court's going to see you as part of the problem, even if that's not necessarily true. So I'm telling you, you can use domestic violence, which includes coercive control, as a basis for a modification to seek it. You have to have a substantial change in circumstances to change your parenting plan. And domestic violence, especially if you have credible evidence to support that, can absolutely be a basis for changing it. So that's something to think about. I really feel for parents that are stuck in resist refuse situations, because it can be really hard to be the parent trying to force the other child to go, especially if you think it's not good for them. So if so, you need to look at other ways to deal with it, if at all possible, if there's really a safety concern. Otherwise, you could be in a situation where then you get nailed for it, and then someone tries to take your residential time away. And there's not much of a worse situation for you or your child if that happens. So.
Thanks,
Okay.
Michelle. Quite a few other questions. I just want to ask one more about coercive control. How
Go.
can you prove coercive control? Is that a thing?
Text messages. Here's the thing too. I talk about evidence, right? Like I talk about text messages, recordings, things like that. Third party declarations, people who observed this kind of things going on. But usually coercive control is done kind of in quiet and silent. It is not, a lot of other people don't see it. So if you have messages, that's helpful. But evidence can come from you. You can draft a declaration saying he or she did XYZ, said these kinds of things to me. This is how long it's been going on. This is the situation. Your testimony is evidence of what has happened. It's helpful if you have things to kind of substantiate what you said, but what you say matters. And in a protection order, the most important thing that's going to be in there is going to be your declaration talking about what happened. Tell us what happened. She was always doing this to you. Every day she tells you you're a lazy piece of crap and you're not good for anything, and that's been going on for years. Put it in your declaration. You don't have to have something else besides that. So your words speak volumes and are very powerful, and that should feel empowering to you. So, all right. Anything
Okay,
else?
to ask a couple more questions, or do
Go
you
ahead, a
want
couple more. Yeah, go for it.
You were talking a little bit earlier about if people are accused of DV and how to defend against it. This question is kind of relevant to that. If the police were called multiple times but didn't arrest me because no laws were broken, would that help in defending a DV case? or videos of an argument are presented, but the videos are without consent, show a one-sided
Well,
perspective,
they're not going
etc.
to be presented if they're without consent. They're not going to come into court.
Okay.
I will tell you one thing though. Evaluators, parental evaluators, parenting evaluators, or guardian ad litems, or some cases, family court services will do an evaluation, or sometimes what's called CASA. Videos might not be admissible in court, but they can be shown to evaluators. I had a case a few years ago that was a pretty extreme situation, and the husband was recording the wife because the wife was doing some things that were crazy and out of control. And some of them some of them probably could have come into court anyway because the husband was defending himself against violence from the wife. Others, maybe not, but the husband was able to take all of them, and the guardian ad litem watched them. And she made a decision based on those things about what was really going on. And it helped shape her perspective, and it helped that client get custody. So I'm not saying that you should record, because if you record without consent, you could be charged with a crime. I've seen that happen too. But if you've got videos and it's like, oh, maybe this would be helpful for someone to see, those might be able to go to an evaluator, and whether the evaluator wants to consider them or not is one thing. But you're not going to be able to play a video in court that there was no consent for, unless it falls under one of the exceptions.
Yeah, and so then if police are called and not arresting this person, because would that potentially, I don't know, work to their benefit in defending their DV case?
No, actually, I would say no. If the police, if the police come and arrest you, obviously that helps a case. But there are many times where the police will come and someone will, and it can be for a number of reasons an arrest isn't made. One, someone might say, no, someone might not feel forthcoming about really saying what happened, even if they called the police, or the other person might have another explanation. But a court doesn't necessarily think that the police got it right necessarily. So, I mean, it can help and it cannot help. Just because someone was arrested wasn't arrested doesn't mean something didn't happen. So the fact that someone felt the need to call the police is a big thing. Other times you could flip it around and you could look at it like, oh, well, this person's called the police 5 times and no one's ever been arrested. That might kind of be questionable, and maybe the person that's calling is really the one kind of cause a problem or get someone in trouble. So you can look at it a bunch of different ways. It's really going to be fact specific, but I wouldn't say just because someone didn't make an arrest that that all of a sudden you're not in a good position. Although if you're defending against it, you're like, hey, they didn't arrest me. So it can go either way. That's probably not the answer you want, but the number one lawyer answer is it depends, because it really does.
This is a really good question that I feel like comes up a lot. There's others saying my spouse is volatile and I don't know how they're going to react when they're served with divorce papers. I want to believe that we can handle it in a civil manner, so I'm reluctant to go so far as to file for protection. But what do I do to be prepared for the worst case scenario without immediately filing for protection in case it doesn't go well?
You might want to, if you don't want to file a protection order right away, you could file for a restraint when you file the case. You could try and talk with an attorney about seeing if you could facilitate that person moving out or you moving out before you do these things. Like here's the thing. If you feel that irreparable harm is going to occur to you or your children or your property because this person gets served with divorce, you probably should do something. If you just think that's very different, like this person's going to attack me and try to beat the crap out of me or lock me out of all of our bank accounts or do something really damaging. If they're going to do that, you should have a strategy meeting with counsel to decide how to move forward and what the best way is to protect yourself. If it's just they're going to be mad and they're going to say nasty things to me on a text message like someone does when they get mad, and this is really important, I should put this out there too. Maybe we shouldn't joke about this, but we've even joked about this in my office. Like everybody has sent a bad text message to a boyfriend or a wife or a husband. Just because you said something nasty and called someone a name that you have been in a relationship with doesn't mean that you've committed coercive control or DV. We've all probably sent messages at some point that we're not proud of, but coercive control is a pattern of that behavior, and it is actual psychological abuse and control. That's different than I got mad and I was like, shut the whatever up or at somebody once, like I'm not saying I did that, but like I could have sent a text message to somebody in my past when I was mad, and that doesn't mean I committed coercive control. Same for you, and same for if if your spouse is going to send you a message or call you or say something to you and they're just going to like pop off because they're frustrated once or twice, that's not necessarily coercive control. You don't need to get a protection order. But if someone has told you, you know, multiple times, if you ever leave me, I'm going to do this or that, and you think they really might, or if you think they're going to take actions into their own hands, that is a time to really be careful about your planning. But if you're just worried about someone getting mad, that's different. Because people usually in divorce, one person wants it, one person doesn't, and they're mad. That's just, and you have to deal with that. And then there's ways you can do that. And that's kind of also too, Melissa could talk about this actually for a minute. Um, you know, I can talk with people about the different options that you have, but I also can't tell you emotionally how to deal with getting ready to leave. And that's something Melissa really deals with people on. And so maybe you can say something about that.
Yeah, I'm glad to chime in. I think just in general, related to any situation regarding domestic violence, having adequate therapy support is really, really key. You know, having social supports around you and people in your life who are, you know, loving and supportive and there for you is also really important. But, you know, these are really sensitive situations. And if you're dealing with domestic violence and a family law situation, child custody, there's a lot going on. And it's really hard to kind of separate out. How am I going to show up and be, you know, the parent I want to be when I'm struggling with all these emotions? So I really, really recommend having, you know, therapeutic support to help you monitor how you're doing and to navigate all of this. But on this topic, you know, I work with a lot of people who are sort of contemplating divorce and trying to figure out, you know, how, if they're going to even move forward with it, getting the courage to unpacking whether that's the right choice or do they want to go into marriage counseling. What are the options, right? And I have quite a few clients who I've worked with through the process of, well, this is going to be a really hard, you know, show. I'm going to have to tell them they're going to be upset or they're not going to be able to handle it, or how are we going to work through it? So I work with a lot of people on kind of ensuring that you have your, you know, your emotional supports in order to do that. And even sometimes strategizing on a safety plan. What's that going to look like? Are you going to be not in the home that day or that week, or are you going to be, you know, out of town? Or are they going to be out of town? How are you going to do it? There's a lot of different ways that could look. Who else in your life are you going to utilize to be, you know, part of your village in this process? So, you know, I do think that kind of working through how you're managing this on an emotional level to help you think clearly too and make decisions that are sound and rational is going to be really important, because it's real easy to kind of let emotions lead the charge and drive the ship if you're not feeling grounded and you don't have enough support. So I can't emphasize enough the importance of, in all of these different phases, you know, having emotional support.
It is, and from the attorney perspective too, just to tell you, like if you're accused of violence or you're accused of being unstable or something, I mean, I'm not saying like get a therapist because it looks good, but get a therapist because it looks good. Like it looks good if you're working with someone and taking care of your own mental health. It kind of makes it the other person probably isn't doing that, or even if they are, great for them. But like it's helpful to have a therapist on your side too that can say, hey, this person's been seeing me, they're working on their stuff, you know. Doesn't mean the court gets to know everything you're talking about, but the existence of a therapist relationship is helpful to someone. And very often in custody disputes, it's recommended or even eventually ordered in a parenting plan that you get a therapist if you don't have one, by recommendation of a guardian ad litem or a parenting evaluator or whatever. So you're kind of ahead of the game if you're going through a stressful divorce and you have a therapist on your side. I can't stress that to you enough. So to my 2 cents about that. I know we only have about 10 more minutes and I can talk about a few more things. I'm going to talk about one more thing and then I'll just answer the questions the rest of the time. The thing I really wanted to talk about is restrictions in your parenting plan. So a reason to restrict things in your parenting plan, like time with children and decision making, are what we call the 191 factors and restrictions. They're sections 3A and 3B in your parenting plan. And they're domestic violence. A finding of domestic violence is a basis to restrict contact between a parent and child, and a mandatory decision making restriction. Decision making is like non-emergency medical, extracurriculars, education, and you don't want those kind of restrictions if you're co-parenting. But if you have a DV finding, that can be a basis for restrictions. Courts can also order supervised visitation. So if someone is a DV perpetrator and there's been a finding of DV, or even if there hasn't been one yet and there's concerns, then you know, supervised visits by a professional supervisor, or in some instances a lay supervisor, can take place to make sure a child can still have contact with the parent, but that it can be safe. But other bases for restrictions besides just DV can include substance abuse, mental health issues, any number of things, other addictions. But here's the key. In other things like that are not DV, DV is serious and it affects the whole family. Other things, like you could have an alcohol problem, and that doesn't mean there's a restriction in your plan automatically. A lot of people have alcohol problems that might be under control, or there is not a nexus between someone's drinking and their parenting functions. If someone's drinking and they're never drinking around the kids and it's never affected their parenting, then the court doesn't care. If someone has, many people have, someone will be like, oh, well, if I go to counseling or therapy, isn't that going to be used against me? Doesn't mean there's something wrong with me? No, it's actually usually means you're in a good place. But if you have mental health issues that are untreated, or if you have mental health issues that are so severe that they affect your ability to parent, then there's a nexus between your mental health and your parenting. If you have, chemical dependency issues and there's a nexus and you can't get up to take your kids to school, or you're driving with your kids in the car while you're under the influence, there's a nexus. So those are all basis for restrictions in your plan. You need to be very aware, though, that if a protection order enters against you, it can be a basis to severely impact the outcome of your parenting case. So I wanted to just make sure and get that out there. Those are things that are really best discussed specifically. We could probably do a whole hour on that. I think I actually have in the past, so you could probably find one. This just touches on it briefly, but I'm happy. I know there's more questions, and I'd rather answer your questions for the last bit of time we have together.
Yes, great. There are some more questions. Okay, if there was a court ordered a GAL and both parties agreed and then asked the court to rescind the GAL and that was approved, is there any way to get it back now if there's new concerns?
Probably shouldn't have done that. It's one thing to tell you. But a lot of time too, it's not uncommon. Everyone's like, oh, everything's fine. We really didn't need this. If you went and got a GAL in the first place, you probably needed it. But that's not uncommon. And if something new has happened, then you could motion for a guardian ad litem again. The other party might not agree, and the other party might oppose it. And you better make sure something new has happened. Because if it isn't new, then they're going to be like, well, it wasn't as big of a concern for you to have somebody appointed. But, it doesn't mean just because you agreed to, I had a case where we had agreed to dismiss it, but we put in our temporary order that either party could renew it upon the request for a guardian ad litem, and the other party would agree to it upon anything in the future that met a certain criterion. Most people don't think ahead to do that. I did that specifically so something like this wouldn't happen. But you could ask, but be sure that you're not just basing it on things that happened before. Or if you think, I guess it just depends on the reasons that you agreed not to have the evaluator before. You can definitely get one even if you agreed not to before, but you want to make sure it's well supported, especially if you're going to have to bring a motion for it that the other side's going to oppose. Usually the first time you ask for a guardian ad litem, if there's kids or a parenting evaluator, you're going to get one because the court wants there to be more information. The court doesn't want to have to make a decision about where your kids are going to live with very limited information. They want an evaluation to read. They want somebody to dig into what's going on. So usually when you ask for it the first time, you're probably going to get it. But if you've already decided that you didn't need one, the court's going to take a closer look than they might have. So you just want to be prepared. Doesn't mean you won't get it though.
Okay, another question, when we're talking about what qualifies for domestic violence, maybe coercive control, what about manipulation of the child and dismissing mom's responsibilities and kind of maybe
Yeah, I mean, talking about that can be harder, and you're probably going to need an evaluator. And I want to talk about evaluators for a minute too. But you're probably going to need an evaluator because you can't go into court and be like, my kid said dad said this, or my kid said mom said this, which is what I said earlier. You can't do that. I mean, you could in a protection order filing, but without some independent corroboration. You don't want to make your child kind of like the star center of why you're getting a protection order, even if it is why. But like, you don't want your child's words to be the whole thing. You need something else to independently corroborate it. It's not that, and in a family law action, that stuff won't come in. You won't be able to get that information in unless it's already come in through a protection order. You'd probably be well served to have a evaluator, because evaluator will actually talk to your kids. And that's how that information really can come in with credibility. Like, so parenting evaluator is someone that evaluates parenting. There's a psychological component, psychological evaluations. It's a more in-depth evaluation of actual parenting. A guardian ad litem is someone who their job is also to do an evaluation and make a recommendation on parenting. And their job is to stand in the shoes of the children and do an evaluation. So they're different types of evaluations, but they serve the same purpose. Both evaluators will talk with your children. They'll talk with each of you, they'll observe you with your children, and they'll talk with your children. And depending on, what is said there, that can form a very strong basis for recommendations. And I have seen recommendations for restrictions based on coercive control come out of those kinds of evaluations.
Thank you. Another question, I guess, about what qualifies. This person's saying that for years, their wife repeatedly threatened divorce and claimed that they'd never get custody of the kids, saying the courts would never agree to it, led them to stay in their relationship for much longer than they wanted to. Could any of that be considered coercive control or emotional abuse under the
Not
domestic
really.
violence?
I mean, if someone's just threatening to leave you, well, that happens a lot. I mean,
Yeah,
it's
or
doing it in a way that's like,
more like telling you that no, you'll never get control of the kids, you have to stay.
maybe. I
Otherwise,
mean, that alone is probably not like enough, but I mean, a lot of people say that, but if it's like, I'm going to take the kids away from you and you're never going to see them. Yeah. I mean, that could be it. I had a case not that long ago where it was like, I'm going to take the kids and I'm going to go to Russia and you're never going to see the kids again, and that was a real fear. So, I mean, that can all factor into the bigger picture, but just someone saying, I'm going to leave you and you're probably not going to get the kids. A lot of people say, I'm going to leave you, you're going to get nothing. So, I don't know that that's not necessarily coercive control. It really depends on the fact specific information in your situation, but maybe it's a piece of a bigger puzzle.
yeah. Okay, let's see. In a situation where they're divorced but still experiencing coercive control, they have a parenting plan. If related to the dynamic, if coercive control is still going on even when divorced, what are the recommendations on how to
Yeah,
manage
I
that?
mentioned that. I mentioned earlier that I recently got a coercive control protection order. Those people had been divorced for 4 years, and the communication from one party to my client was so abusive and so controlling, and it was affecting the parenting and affecting everything that we had to get a protection order. It's the only thing that's helped. And those are people that have been divorced, like I said, for 4 years. So, I mean, it can happen, and that the abuse and the coercion can be in the context of the parenting relationship. You hope it's not, but in real extreme circumstances, it might be. And the best way to handle that, like in our situation, in this particular case, it always sticks out for me. We tried everything. Like we really tried, we had our family wizard, we had a parenting. These people even had, a parenting coordinator. They had 3 different ones because the other party was so abusive that they kept quitting. But like, you try everything you can. A parenting coordinator can be really helpful too if someone just like can't hold themselves together. That can be evidence that can help document on your side to support a modification for you to have more time or sole decision making later, or to help support a protection order if you end up needing it. So yeah, if someone's persisting in that kind of conduct, basically you put them on notice in writing. Your conduct doesn't serve any legitimate purpose to be talking to me like that. Keep it to the kids. Stop trying to control what I'm doing. You have an attorney put them on notice. And if it still continues, sometimes you have to take action. I'm not saying everybody's going to get a coercive control protection order against their co-parent, but it happens in real extreme circumstances. And the court has really started to recognize even more over the last year, ever since it's been a year and a half now, I think, a little over a year since the statute changed. At first, people didn't really know how to handle coercive control or what to do with it. But now it's becoming accepted that this really is domestic violence that needs to be taken seriously by the court.
Okay, thanks. There's a couple more questions. I'll try to get them in.
Right.
This person is describing a situation where they're representing themselves pro se. And okay, it's a little bit fact specific, so I'm gonna try to generalize. The other party was recently incarcerated and didn't tell them, and apparently has given their family access to the Talking Parents account to impersonate them. And so any advice about presenting the safety concerns of the child to the court for this scenario?
Mm-hmm. Okay. Um, yeah. If somebody was especially if somebody was incarcerated, that is not, if someone was incarcerated and didn't tell you, that can be a basis for modification of your parenting plan. Especially like what were they incarcerated for and like what was going on in their parenting time. And if they were doing things like having other people like speak for them, so you wouldn't know they were incarcerated. I mean, all that is a very serious concern. You could potentially seek a modification on that basis.
Mhm.
So
Yeah, it sounds like it's a really complicated situation,
yeah.
so definitely.
Talk to an attorney. I mean, that doesn't sound good at all. So yeah, I'd have real concerns about that person. I have time for one more before we go.
Yeah. Okay, of the various levels of protection and restraint, will all of them be placed on someone's record and negatively impact their life, such as the ability to get a job or find a new place to live in the future?
A protection order?
Yeah.
Yeah, I mean, it could. No, a protection order is a civil order. This is a good opportunity to talk about that. Protection order is a civil order. It's not, it's a civil order. It is not, necessarily a bar to all employment, but employment in places like schools, ability to drive on your kid's field trip, pass certain background checks can be impeded by a protection order. Your ability to live certain places, it's, not every apartment building is going to deny you, but it can be, depending on their screening factors, a basis to deny that for you. So yeah, it can have impacts. Other times you might not have an impact at all. I had somebody not that long ago who had a protection order and they'd forgotten about it. It was a really long-term one, happened like 20 years ago. And then they tried to go to Canada and if they got flagged and they had never gone before that. And that was a real problem and they couldn't go. So, little things like that also too can come up. So anyway, you guys had a lot of really good questions. Thank you for coming. If we didn't get to your question, I'm sorry about that. But you can watch this webinar online. It'll be posted on our YouTube channel and you can find that from our website. We also will, there's a bunch of other ones there too, if you want to check them out. Hopefully it's helpful for you. Melissa's posting our contact information. Thanks so much. We do a webinar every month, so there will be another one next month. Melissa, do you happen to remember the dates off the top of your head? I don't. I can check though. Hang on. Unless
See,
yeah.
I do. I think it's October 17th.
Okay. October 17th, we'll have another webinar. We also have a meetup group that we met last night. So there won't be another one until next month, but we do meet one Wednesday a month. It's called the Do's and Don'ts of Separation and Divorce. You can also link to that from our website at DellinoLaw.com. There is it'll take you to meetup.com, which is where our sign up is. We do online a lot of Q&A group meeting once a month. And then we also do quarterly in-person meetings as well. So you might want to check that out as another resource. Anyway, thanks for coming. I really appreciate your time. Hopefully this was helpful to you. And no matter where you are on your case, I wish you the best of luck. Take care. Bye-bye.
Yes, thank you, everyone. I'll leave the contact slide up here for just another minute. If you wish to reach out to either of us, and yes, wish you well and everything that lies ahead. Come see us again. Thanks.